And we're going to, maybe I just start sharing 1 second. Yeah, so you're going to be also here through the, that. And the people online will hear you through this if you can stay semi-close to that. Oh, sorry, I can just do this one. And so, okay.
To move out.
Yes, you're going to be able to.
Full screen.
Yes, sorry. There we go. From the beginning, you should be able to do with the buttons. Is that okay? Okay. So can I introduce you? Is that okay? So for our next session, and we have Moataz El Fegiery, as he is an assistant professor and head of the Human Rights Program at the Doha Institute for Graduate Studies. He was a senior teaching fellow of law at the School of Oriental and African Studies, University of London. He has extensive experience in human rights research and advocacy in the Middle East and North Africa, and represented key international human rights NGOs, including the International Center for Transitional Justice and Frontline Defenders. He was the executive director of the Cairo Institute for Human Rights Studies and is currently a member of its board of directors. He's also the treasurer and member of the executive committee of the Euro-Med Rights. His research focuses on the interaction between Islamic law and human rights in the Arab world and the evolving dynamics of human rights and human rights movements in both the Middle East and North Africa. He received his PhD in law from the School of Oriental and African Studies at the University of London. You're very welcome. Okay. And yes, you unmuted. And
okay, thanks a lot for this introduction and for the invitation. And it's a great honor to be with you today. So I'm going to reflect on what you already heard. I mean, on hate speech, incitement to discrimination and violence in the Muslim world, different context of religious freedom and freedom of expression, and how this issue is being addressed politically and by different courts. And I will mainly focus on Egypt, but what I'm going to say is also valid to many countries in the region, with some differences, which I will show in my presentation. This issue is very topical today in the Middle East and North Africa. It has its own political and legal consequences in the region, but it also has repercussions in Europe, as we have seen since Salman Rushdie in 1980s and the Danish cartoons and Charles Hebdo drawing. So it is something that creates crisis from time to time. But the debate in the Arab region or in the Muslim world is different somehow from the debate in Europe. I assume that you discussed the European Court of Human Rights and how the European Court approached this issue. There are some similarities, but in the region, the level of discussion is different because the level of prohibition is also different. The scope of prohibited speech is different. So what I'm going to address today, first, we will need to lay the scene for our presentation. So we will start with the changing context, the emerging issues in the Muslim world and how to look at this issue in the Muslim world. Then I will discuss a little bit origin of blasphemy laws. Is it Sharia or modern construction? Because there are some overlap here between Islamic law, Islamic concept from the traditions, but also reconstruction, modern reconstruction of this concept. Then we will move into blasphemy laws in the Muslim state, key problematic issues, what are the main issues in these laws. Then I will address 2 or 3 cases, summarize what we are discussing. Then I will tackle the prospect for law reform in the region, because this is very important today in the Middle East, how this law can be reformed and what are the adequate approaches to reform this law. This discussion is not like supplementary in the Middle East. It is essential today. It is essential for many reasons. Because of the religious polarization that we have seen, that also take violent form in Iraq, in Yemen, sectarian polarization or sectarian violence in Egypt, violence against Muslim dissident also, liberal or secular Muslims. So the issue is very important also for religious reform debate on religious reform and Islamic law reform. And of course, it has also some consequences on Muslim state relation with Western societies. And this debate also was very intense at the UN Human Rights Council, as I'm going to discuss. So this is one of the most challenging and topical issue in the relationship between religion and human rights in the Muslim world. Why it is very challenging? Because it intersects with politics, with religion, religious identity, Islamic law, religious feelings. So it is not just about religion. It is also a source of political propaganda. I would say it is very difficult today in Muslim countries to reform blasphemy laws. And any politician who wants to reform blasphemy laws is confronted with upheaval and sometimes violent, as we have seen in Pakistan. So it is easy to pass these laws, but it is very difficult to reform or to touch these laws. The same in Egypt. This law existed in Egypt since early 20th century, and it was reformed throughout 20th century. And today there is ongoing debate to reform the law, but all reform attempts have failed because of the political circumstances. Also, politicians are reluctant to touch these laws or to propose reform. And on international level also, it is very embedded in identity politics. So you can just, confuse between like discrimination against religious minorities or migrant with attack against religious doctrine. All of these issues are interconnected together. So law reform has failed and confronted by protest and violence. On domestic level, there is high or growing criminalization of blasphemous speeches in the Middle East and North Africa. In many countries in the Middle East, there are criminalization of blasphemous speeches, and criminalization takes different form. It can be just like direct criminalization against insulting the messenger, insulting prophet, or insulting religious doctrine, or insulting religious scholars, sometimes also in some laws. I will show you article of some laws that adopt a very vague provision of the definition of the blasphemy. Or sometimes it also bring death penalty in Pakistan. So one of the famous blasphemy law in Pakistan that also invoke death penalty. On regional and international level, the debate on blasphemy has taken also different form. For example, this is the Sheikh al-Azhar, the leader of al-Azhar in Egypt. In October 2020, he called international community to criminalize anti-Muslim actions. This is following the image being displayed in France of the Prophet Muhammad. So this was not the first time a respectable Muslim scholar called for criminalization of blasphemy. Former Muslim Brotherhood leader Mohammed Morsi, who was the president of Egypt 2011, 2012, 2013, at the UN General Assembly also he called for international convention against blasphemy. Organization of Islamic Cooperation, OIC, also in its newly adopted declaration of the organization, Islamic Declaration on Human Rights, it has a specific article, Article 21, freedom of expression should not be used for denigration of religions and prophet, or to violate the sanctities of religious symbols, or to undermine the moral and ethical values of society. Well, I have to say that the version of the Cairo Declaration is much more developed than the first version adopted in 1994. Comparing, if we compare between the two versions, we can see that this latest version improved the content on rights of women, on rights of religious minorities, on freedom of religion. But when it comes to freedom of expression, it was mentioned directly. So there is no implicit language, but it's very explicit language that against blasphemy speeches. So this is a fundamental issue for the organization of Islamic cooperation. I mean, for me, mentioning only freedom of expression and limitation on freedom of expression is much better, because you can find ways to expand the scope of freedom of expression. But by making this reference, it has become very difficult right now to debate the question of blasphemy and law reform under the Cairo Declaration of Human Rights in Islam. So the Cairo Declaration of Human Rights in Islam has received also much critique since 1994, and that's why the OIC modernized its version, but in this version, there is direct reference. This reference did not exist in the first version, 1994. But in the newly adopted version, there is a direct reference to blasphemy. The debate generally in the Muslim world is different from European context. How it is different? Because the threshold of prohibition is also different. I mean, in Europe, most of the cases at the European Court of Human Rights, it dealt with somehow, I would say, provocative speeches or provocative form of expression. In the Arab region, the scope is much more larger. I mean, critical engagement of religion can be also prosecuted under blasphemy. So it is not just about abusive or provocative approach to religion. It is different form of expressions that can be taken into court under blasphemy laws. So this is one thing that differentiates the debate from Europe and the Muslim world. Also, the nature of cases is entirely different. Nature of cases, like there are cases against Muslims, against non-Muslims, but a lot of cases also against religious minorities. And these cases and the number of these cases are very much connected with political context. So, for example, if there is polarization between liberal Muslims and Islamists, you can expect this kind of cases. It happened in Egypt. Yani the curve of cases was very high after the revolution, 2011 until 2013. This is because there was also growing influence of Muslim Salafist, Muslim Brotherhood, polarization with liberal Muslims. So a lot of cases emerging, especially against non-Muslims. You can see the same pattern in Pakistan. That's why it is very politicized. This debate is very politicized. Also, the punishment is different. I mean, in Europe, we are talking about fine or censorship, but in the Muslim world, we are talking about imprisonment, like 5 years or 20 years, or death penalty. So this is also different landscape. And finally, there is overlap in many Arab legal systems between blasphemy and the incitement to religious discrimination or violence. The lines are blurring in the region between both. So, for example, human rights defenders in the Middle East will be a little bit reluctant to call for Article 20 of the ICCPR in the region because they expect this kind of overlap between incitement to hatred or incitement to violence, incitement to discrimination, and prohibition of blasphemy. Usually, there are no differences between both. So some laws in the region can talk about incitement to discrimination, religious discrimination or religious violence, but at the same time, this is the same article used against blasphemous speeches. So this is also a key difference between Europe, the debate in Europe, and the Arab legal jurisdictions, because I would say internationally and in Europe, the discussion has progressed a little bit in how to define the crime of incitement to discrimination, incitement to violence. And despite that, it is ambiguous, but there is growing clarity on the element of the crime. But in Arab courts, there is no clarity. Usually, you can just remove blasphemy article and keep incitement to violence or religious discrimination, and it is also used against blasphemous speeches. So this is important to keep in mind. Well, origins of blasphemy laws, Sharia, is it Sharia or modern construction? Well, it's very important here to keep in mind that things are not directly connected to Sharia when discussing blasphemy in the Arab region. Yes, in Islamic history, there is substantive discussion and so very sophisticated discussion of the crime of insulting God, insulting the Prophet, apostasy, discussed by jurists, and I'm going to explain the main trend within Islamic traditions. But Arab modern court do not discuss these issues substantively as it was discussed by Muslim jurists. Usually in these cases, you can feel more political ideology, identity rhetorics, public order, security, or religious feelings, rather than Sharia per se. I would argue that if we apply Sharia per se, we can find loopholes actually to mitigate the punishment or even to remove the punishment completely. But Sharia has been taken from its context. So in modern court, yes, you can find the same concept, the same terminologies, but judges do not apply the same reasoning applied by Muslim jurists. For example, there is one sentence exists in Muslim scholars' literature called denying what is necessarily known of religion. إنكار ما هو معلوم من الدين بالضرورة in Arabic, denying what is necessarily known of religion. This can be taken as an evidence to invoke apostasy or blasphemy. But Muslim jurists disagree on what do you mean by denying what is necessarily known of religion. You can see Egyptian court repeating the same sentence in many of its judgment, denying what is necessarily known of religion. Against scholars, for example, who debating Muslim family law, calling for equality in inheritance, or attacking some radical Muslim scholars, something like that. So judge can use the same sentence taken from the Muslim fiqh books and apply it to modern cases. But Muslim scholars traditionally disagreed. I mean, each scholar has different approach of what he meant by denying what is necessarily known of religion. Especially that we know that the development of Islamic law itself came as a result of diverse views, and the process was not centralized. I mean, there were hundreds of Islamic schools and centralized into 4 Islamic schools, but within each school there are a lot of views and a lot of opinions across 13th century. So it is not that simple, to say, for example, what is the position of Islamic law on apostasy or blasphemy? No, there is no one answer for that. But Arab court give you one answer, like Egyptian court give you one answer. But this is not the real discussion of the Islamic fiqh. It is much more complex than that. So anti-blasphemy provision incorporated in penal code under colonialism. So we have to consider that in the beginning of the 20th century and late 19th century, some Muslim penal code copied same articles existed in French code against blasphemy. It was not Sharia at that time. I can here refer to the first Egyptian criminal law. The first Egyptian criminal law, which was influenced by the French penal code, it adopted an article on blasphemy, and it was applied in some cases. But the reasoning of judge at that time was mainly focused on protection of official religion or public order. No discussion of Islam, no discussion of Islamic doctrines. And there were few cases actually at that time. Then gradually, Islam and the Islamic law have been selectively invoked by judge. So the first intention of the lawmakers was not to endorse Sharia in the penal code. It was just the same positive French code that was adopted in Egypt, but gradually, because of the changing political context in Egypt, it started to integrate Islamic doctrine, Islamic discussion in judge reasoning. And I have to tell you something. For example, in 1982, when the Egyptian government adopted a new blasphemy law, it was actually adopted at that time to be used against radical and extremist Islamist group, not against liberal Muslims. And it was adopted amid violence, religious violence, and at that time, the Egyptian government amended the penal code and endorsed the blasphemy definition in the penal code, but it was meant actually to be used against radical Muslim. But later on, because of the litigation of Islamist group, litigation of association and the lawyers, the level of criminalization has expanded in Egyptian court. We can also discuss the influence of Islamic law on blasphemy, heresy, and apostasy. This is very important when discussing blasphemy in the Arab region today. There are some kind of overlap between the three concepts: blasphemy, heresy, apostasy. There is influence of apostasy, defining apostasy, and the element of apostasy in also defining the crime of blasphemy. So courts do not usually, as I said, discuss the rationale under Islamic law, but there is some kind of influence. You can feel it from the terminology, but it is not in the same manner discussed by Muslim jurists. So for example, if you are discussing a very famous treatise published in Islamic, this is one of the famous, it is a guidebook of Muslim who advocate blasphemy law today in the region. Al-Sarim al-Maslul ala shatim al-Rasul, the sharp sword drawn against those who insult the messenger. This is a major reference used today. It's written by Ibn Taymiyyah in the 13th century. But if you look at the book, actually, this is very big sized book. There are a lot of views within this book. I mean, there are different trend, competing trend, and Ibn Taymiyyah displaying, presenting these views, and of course introducing his own view. So in this book, if you look at the definition of the crime of blasphemy, you have this intersection between, or overlap between, apostasy, heresy, blasphemy. Apostasy in Islam, there is subjective, objective criteria. Subjective, that someone convert freely from the religion, says that I am not Muslim anymore, so he or she can be considered Muslim. But the most challenging criteria is this objective one, to judge that a Muslim is apostate. And in this case, this can be considered blasphemy as well. Okay, so blasphemous speech can lead the person into apostasy, and apostasy has its own legal consequences. Muslim jurists, when they were discussing blasphemy, they were mainly discussing insulting the messenger, insulting God, using language that is abusive against God and against the prophet. But at the same time, today, in some court today, when judging that a person is blasphemous, this can be taken from the apostasy evidence. So for example, writing a book discussing a religious doctrine or refuting something that is a source of consensus between Muslim scholars, can be considered apostasy and blasphemy at the same time. So blasphemy is not just abusive language against the prophet or God, but it also violating the consensus of Muslim jurists. This is the overlap between blasphemy, heresy, and apostasy. And because today in Muslim state, there is no crime, and very few Muslim states that has a crime called apostasy. Like for example, in Egypt, there is no crime called apostasy, but there is crime called blasphemy. So that's why judges use the same doctrine of apostasy and apply it into blasphemy. What is applied in terms of apostasy in many Muslim countries, the legal consequences of apostasy. Legal consequences mean if a Muslim proved to be an apostate, he or she can be dissolved from marriage, can be dissolved, denied from inheritance. Okay, so this is the legal civil consequences, but there is no criminal consequences except in Sudan, and this law was removed, and in Iran, of course, This also exists, and in Saudi Arabia. But most Arab countries, there is no criminal punishment for apostasy. So blasphemy law now acting the same purpose of apostasy law. And many Muslim jurists viewed blasphemy as part of Islamic hudud. Islamic hudud, I mean, for those of you who are not familiar with Islamic law, there is different type under Islamic criminal law. There is hudud, which is fixed punishment, or there is discretionary punishment, ta'zir. The challenge in reforming blasphemy law is when Muslims consider it fixed punishment, hudud. And some, I mean, many Muslim jurists traditionally viewed blasphemy as part of Islamic hudud, fixed punishment, which is punishable by death. And they disagreed whether repentance is allowed for the perpetrators of the offense or not. There is disagreement here. But there are other scholars also who argued that blasphemy is to be addressed under discretionary punishment in Islamic criminal law. And this is, I would say, this is an option for reform. If Muslim jurists consider it ta'zir punishment, so reform can happen here. So shifting this crime from fixed punishment into ta'zir opens the gate for reform. Because if it is fixed punishment, it will be a little bit hard. And this is the approach taken by Pakistani court. For example, Pakistani court consider it fixed punishment, punishable by death. Despite the fact that we cannot 100% say that Islamic jurists, there was an agreement between Islamic jurists that blasphemy is a had punishment. This didn't exist in Islamic tradition because there were disagreement between Muslim scholars whether this is had punishment, fixed punishment, or discretionary punishment. If we there is two examples here to see how apostasy and blasphemy are interconnected debate in the Muslim world. This is Mahmoud Muhammad Taha, Nasr Hamid Abu Zaid, two very famous cases, one in Sudan and one in Egypt, 1985, 1996. Despite the two cases are old, but they are still important precedent, especially this case in Egypt, because the Court of Cassation developed certain principles in this case that are valid until today in Egypt. So let me start with Nasr Hamid Abu Zaid. He is an academic, Egyptian academic, who was working for Cairo University, and he was applying. Then the committee examined his research and books, and that the content of his book can be considered an act of apostasy because he refuted agreement between Muslim Jews. So they referred his research into the prosecution. In Egypt. The subject issue of this case was to solve his marriage. And in order for the court to judge that the marriage is void, they need first to establish that he is apostate. So the court started to discuss his academic contribution, his discussion of Islamic legal issues, and concluded that he committed the act of apostasy and used this doctrine denying what is necessarily known of religion. So Nasr Hamid Abu Zaid, he was debating the nature of Quran, the ijtihad, and how Quran can be read in a socio-historical manner, and he was criticizing the literal interpretation of Quran and Sunnah. So the court in 1996 concluded that he committed the act of apostasy and dissolved his marriage. The doctrines that are until now they are applied in Egyptian court. First, that an apostate marriage is void. If a Muslim found committed the act of apostasy, so his or her marriage is void, and the marriage should be dissolved. Second, that an apostate also to be denied of inheritance, and these doctrines are well-established doctrine in the Egyptian Court of Cassation until today, based on this case of Nasr Hamid Abu Zaid in 1996. The other case is much more dramatic because here is the death penalty, which was applied against Mahmoud Muhammad Taha in 1985. Mahmoud Muhammad Taha is the founder of the Muslim Republicans in Sudan. Muslim Republicans, they were calling for also like new reading of the Quran by abrogating, like the idea of Mahmoud Muhammad Taha is that there are some sections of the Quran that abrogate other sections. And he developed this methodology in order to just challenge inequality or any like hierarchical ruling in the Quran. So the court also judged that Mahmoud Muhammad Taha committed the act of apostasy and sentenced him to death. And he was executed in Sudan in 1985. Both cases are very important, but this case, when it comes to Egyptian legal tradition, until today, as I said, it developed key legal doctrines that are applied by court today in Egyptian cases, especially on apostasy cases, and the intersection between apostasy and civil legal consequences. So, if we look here at examples of the blasphemy laws, so this is the Egyptian article in the Egyptian criminal law. I mean, article, how broad is the article? And this is the last version of the article that was adopted in 1982. So Article 98 impose up to 5 years imprisonment on whoever make use of religion in propagating extreme idea for the purpose of inciting strife, ridiculing, insulting a heavenly religion or a sect following it, or damaging national unity. Here we need to consider, as I said, in 1982, there was violence committed by Islamist group, and the state adopted this article in order to be used Muslims against violent group, because here you see here's a reference to inciting strife, insulting a heavenly religion or a sect. They were also increasing sectarian violence against Christians. But later on, this article was used. It was used against liberal Muslims and thinkers, academics, okay, who starting to challenge certain conservative doctrine of Islam. So the article has been broadened, and the content of the article has been broadened by Egyptian court, and also gave it an Islamic flavor, and using some conception from Islamic traditions, heresy, blasphemy, apostasy, to develop their reasoning in different cases. Article 160 of the Penal law provide up to 3 years imprisonment for the destruction, vandalization, or desecration of religious buildings, sites, symbols, cemeteries, and graves, as well as the obstruction of religious ceremonies. Just when you look at this article, it's normal, but how it is used also in Egyptian cases, it is used in a very restrictive manner, mainly against minorities, and most particularly against Shia Muslim in Egypt, because Egypt is the dominant doctrine is Sunni. So, for example, there is a famous case for a Shia Muslim who was praying in Egyptian mosque with Sunni Muslims. So Sunni Muslim observed that he acting differently. They started to beat him, and police came, arrested the Shia Muslim, and he was sentenced to prison by this article. So this is also something we need to consider. Sometimes the intention of making the law is just, I mean, anyone just looking at this article, it is normal if you attacking mosque or church, and there is punishment, but how it is used by judge is different. How the interpretation of this article is very vague and very broad. This is in the Pakistan Penal Code. The Pakistani Penal Code, this is a very famous article 295. It mainly focuses on the Prophet. Nothing is the Prophet. This article is broad. It's about religion in general. And in this article, by the way, it should protect all religion, not just Islam, even Christianity. There are some Muslims who were prosecuted of blaspheming Christianity, but very few cases. Very few cases. Most of the cases used or invoked against Muslims or Christians who attacking Islamic religious doctrine. But there are few cases for Muslims also arrested or prosecuted for their speech against Christianity. But very few cases. The Pakistani article, it's more about insulting the Prophet, and it is punishable by death. Punishable by death because the court, the Sharia court in Pakistan, in its reasoning established in 1980, 1990, it considered had the punishment, fixed punishment. Fixed punishment, punishable by death. And I said in the beginning that, I mean, there is no consensus between Muslim scholars that blasphemy entail fixed punishment. But this is how the court in Pakistan opted to this view. I mean, the choice made by the court was that blasphemy is punishable by death. And of course, there are a lot of cases that involved Christian in Pakistan who were also punished for this, despite the fact that in Islamic traditions, non-Muslims, there are many scholars who argue that non-Muslims should not be punished by death if they committed blasphemy, and it's just discretionary for the ruler to impose the penalty. And there are minor scholars who said yes, they are punished to death like Muslim blasphemies. But here, as I said, in modern court, I mean, there is one choice. The judge or government need to take one choice of the law, and of course, in many of the cases, they opted to the conservative view of Islamic. And we have to consider also the political background of this article. This article in Egypt was adopted in a context of combating terrorism. But later on, because of the activity of Islamist movement, Islamist group, it has become very difficult to touch it or to change the reasoning of the court. But I will explain to you that today there are judges in Egypt who try to reformulate the reasoning, and this is very promising and positive attitude of Egyptian judge that is still in the making, and not supported by the mainstream judicial practice in Egypt. So to summarize, what are the major issues in these laws based on the two articles? First, the wide scope of the offense, very wide. It's wide scope, it is not just about abusive manner or addressing religion in an abusive manner or provocative manner. It is any kind of speeches that can be considered by authorities blasphemous or attacking religious doctrine. Secondly, there is no proportionality between the offense and the penalty. It's not just about censorship or fine, it's about death penalty. So there is no proportionality between the offense and the penalty. Third, there is also, of course, a tendency in this law to protect the dogma, to protect the mainstream views of religious law and religious theology. So religious reform and the change cannot happen, because today in Muslim countries, I mean, a lot of even media personnel have been charged of blasphemy for just commenting on Islamic legal issues. I would tell you an example. Tunisia recently started to debate reforming personal status law. And Tunisia wanted to, there was an initiative to apply equality in inheritance in Tunisia. This issue in Egypt considered blasphemy and apostasy because it is a source of agreement, because inheritance is based on certain texts in the Quran. And according to many Muslim jurists, there is no ijtihad on certain texts in the Quran. So here, I mean, using blasphemy laws can also impede law reform, because you will not be able to discuss these legal issues and you will not be able to mobilize in order to reform these laws. And of course, impeding academic freedom, as we saw in Nasser Hamid Abu Zaid case. And finally, the persecution of religious minorities. And this is very alarming, especially in multi-religious societies. I mean, by default, Christian will insult. I mean, by default, they will commit blasphemy, and Muslim will commit blasphemy if they discuss other religion. By default, each religion see other religion differently. So how you apply this law? I mean, it's contradictory by nature because once you started to discuss the religion of other community, you can be prosecuted of blasphemy. But the application is biased. The number of cases filed against Muslim or filed against non-Muslim, it is much more higher when it filed against non-Muslim, not filed against Muslims. And at the same time, within Islam, between Sunni and Shia. Ahmadiyya, for example, in Pakistan, they also face the same blasphemy charge. Baha'i community in Egypt, and the Baha'i community is different story because Muslims consider Baha'i apostate. They consider them the Muslim who left Islam, and Baha'i considers themselves independent from Islam. Okay, so blasphemy law also applied also against Baha'i, and there are cases against Baha'i Muslim in Egypt who were arrested and charged of blasphemy. So let us just now take some cases from it. Is there any question? Last the previous section in something not clear or you want to add?
This is very fascinating. I really appreciate this. Like the modern day traditions have been put them together, and how the French laws are then being brought into the Egyptian, but the British law.
Yes,
so they have the same law
same,
in India,
yes,
and the
yes.
same in Pakistan and Bangladesh.
Mm.
Just that the initial laws, again, here, Ireland, they had A, B, and C general as the
Yeah.
and so C then has to do with the Prophet Muhammad. Something, and it's the majority who in danger of getting the blasphemy law.
Mm.
So I think that's extremely, extremely important.
Yeah, this is a key difference also between debate in Europe and the Muslim world, because in Europe, the minority, I mean, invoke blasphemy in order to protect their community. And of course, here there is confusion between protecting individuals and protecting religion. And I tell you, in the Arab region, there is confusion between both. I mean, I know now in the debate globally, you know, it's more toward Article 20, protecting individuals, not protecting religious doctrine. But in the region, there is no, I mean, as you saw, the Sheikh Al-Azhar, who was just driven by Islamophobia, which is, yes, there are, of course, certain acts of discrimination against Muslim, but blasphemy is not the answer. We need to protect individuals, not to protect individuals from discrimination, not to protect religious doctrine, but it exists, it doesn't differentiate. But also there is interest for religious institution to defend blasphemy laws, as I said, because if you want to challenge the legal tradition adopted by this Islamic institution, okay, they will just use blasphemy law to defend themselves, because they just want to end the discussion, no discussion for religious doctrine, so they just invoke blasphemy laws. And this is something that we will discuss in this case, Islam al-Fegiery case in Egypt, 2015. It reflects what I'm talking about, how religious establishment can protect itself by using blasphemy.
It's very good fit, because in Pakistan, which I know better than Egypt, my job here and how we can address this. And she says, you want Sharia courts. So then you go back to what you said, apply Sharia in a different way.
Yes.
Look at the various interpretations. And I think we see
really did not tackle Sharia. Huh?
no.
They tackled the element of the crime.
in line with Sharia.
Yes. Yes.
which I think is a promising step in the right.
Yes. That's why advocating the idea that in Muslim countries that have Sharia code, fair trial, due process is very important. And we have seen cases in Nigeria, in Pakistan, where fair trial and due process can save people from punishment. But the contradiction here is that most Muslim countries, like Saudi Arabia, the fair trial, there is no fair trial, there is no due process. So imagine you apply these laws in context where the judiciary is not independent and there is no fair trial. It's very problematic, because sometimes in Egypt, state security court, you can apply blasphemy law in exceptional court. So there is no right to defense, you know? So that's why I said it's more politicized. This debate is very politicized. But if you are approaching this issue in a well-meaning manner, from an Islamic perspective, there are solutions. There are solutions from within Islamic traditions. And I would argue against those who consider or who just say that, well, Islam is the reason for that. No, it is not. It is not true. I mean, it's how Islamic legal traditions are applied and how it's interpreted. But experience tells us that in political context, usually the conservative attitudes win. Why? Why they win? Because look at Pakistan. I mean, blasphemy law is a source of mobilization for Islamist group. They use it in their propaganda and their electoral propaganda, you know, to mobilize people. Like, for example, in Egypt, Article 2, there is a famous Article 2 in the Egyptian constitution that says Islam is the source of legislation. Islamic law is the source of legislation. President Sadat adopted this article in 1971. Why? Because he wanted actually to extend his term in power. So he introduced a package which include Article 2 with another article that extend his term of power. So people will usually say, yes, of course, Islam is the source of legislation. They will not say no. If you now want to amend this article, it will be much more difficult. It's almost impossible because people will never vote against an article in the constitution that remove Islam. So it's easy to adopt this kind of laws, but it's much more difficult to remove them. So we are left with one option, to try to find another interpretation of the article as a transitional way in order to reform the law. So here there are 3 cases, but this case is very exceptional. It is not that known yet. I wrote about it in the article which I distributed to you. It's related to Adil Imam. Adil Imam, he's a famous movie star in Egypt, you know, and he was actually charged of blasphemy as well because of what? He was mocking Islamists in his movies. So some lawyers filed blasphemy case against him. But actually, because he is famous and he's well known and loved in Egypt, so the judge developed a new reasoning for the blasphemy. Very progressive reasoning, And I will speak about it because I think this is an entry point for reform of blasphemy law in Egypt. But those 2 cases are very standard cases. And if you look at the text of these cases, copy and paste, just use the same reasoning against any person charged of blasphemy. So Islam Al Fegiery, he is a media host. He had until because he was in prison, but he was released a few years ago. So he is a media host. His talk show discuss certain Islamic issues, like for example, wearing the veil, violence by Islamist group, issues related to family law, rights of women. So in each episode, he chooses a topic and just comment on it. And in his episode, he traditional Muslim scholars and criticized Al-Azhar and the conservative position taken by Al-Azhar. And despite the fact that Islam Al Fegiery, this case emerged after the military. I chose this case because, well, we can say, for example, one of the hypotheses that because Muslim Brotherhood was in power 2012, 2013, so blasphemy case was hard. This is not that correct because blasphemy case continued under President Sisi following the collapse of the Muslim Brotherhood. So it's very embedded in society. Yes, it increased under the Muslim Brotherhood because of the Islamist mobilization, but the issue continued until after the removal of the Muslim Brotherhood. Islam al-Bihari, he was close to one of the advocates of the military coup. He's very close to President Sisi. Of blasphemy and sentenced to 5 years in prison. Then the court reduced his penalty to one year in prison. You look at the case. So the judge, what the judge does in this kind of cases? They will first discuss the content of his views. Because of like defining the element of the crime in a way that he incited to discrimination or he incited to violence. No, he discussed the type of views expressed, which is very subjective because you cannot just, how can you, in which criteria you judge these views? So he started to discuss his views. For example, according to the judge, he says Islam al-Bihari was attacking the Muslim jurists. He was calling for suspending the application of Sharia. He was attacking al-Bukhari. Al-Bukhari is one of the leading Sunnah scholar, just repeating his views. And again, introducing this doctrine of denying what is necessarily known of religion, again, copy and paste from other court cases, to conclude that Islam al-Bihari committed the act of blasphemy. And of course, the judge also used certain sentence like, it is widely known that denying what is necessary of religion is prohibited in Islam. But without referring to which school of law you are discussing, which legal doctrine you are discussing, just very, very generic discussion of the principle, then concluded that Islam al-Bihari committed the act of blasphemy, and of course referred to the article 98 of the Penal Code in a very broad manner and sentenced him to prison. In the higher court, they validated the same charges but reduced the punishment from 5 years to one year in prison. Case of Mohammed Fahmi Asfour, 2011. This is another case that target a Shia Muslim. So I talked about it. Mohammed Fahmi Asfour, he is a Shia Muslim who went to pray in a Sunni mosque. Most of all mosques in Egypt are Sunni. So he was praying and his follower just observed that he's doing something abnormal while he's praying. So they started to beat him, attacked him, physically attacking him. And they called the police. Then the police came, found chaos and violence in the mosque. They just realized that the person is Shia, so he was arrested and prosecuted. So those who attacked him were not accused or charged of anything. But Mohammed Fahmi Asfour, he was sentenced to prison under the same article of blasphemy. So as you see, so Islam al-Bihari is a media host targeted. This is a Shia citizen targeted, very normal. He's not intellectual, he is not scholar. He was just a very normal person who went to pray in the mosque. Then he was not lucky because just his colleagues in the mosque provoked of what he's doing. Maybe there was discussion or something like that. They attacked him and called the police. Usually, Egyptian security and like any security institutions in Arab countries, with these issues that threaten public order or doing chaos, they usually, apply. Prosecute the person because in order also to satisfy the conservative communities, because even if they don't believe in it, even if they don't believe in it, because these issues can lead to violence in Egypt, So usually they just apply the blasphemy law in order to calm down the conservative societies. And the same happened in Pakistan also. Part of using or invoking these cases is to calm down the conservative communities in societies. Case. This is the exceptional case. First of all, it is exceptional because the reasoning is different. The language used by the judge is different. It is like came in 40 pages. And the judge here is influenced by UN Human Rights Committee, European Court of Human Rights and Comparative Court. He's a young judge, and he actually introduced an entirely different reasoning on blasphemy. But this is the only precedent in Egyptian court, the only precedent. And it is lower court, not higher court, lower court. And the only precedent, it has not been repeated again, but it is still important because it can be used in order to advocate law reform. I will talk about it. You wanted to say something?
That was actually going to be my question, because President, I was wondering, 2011, 2012 being different than 20. The Fegiery case.
Egypt civil law system.
Yeah, okay.
The lower court, you can just change. Yeah. But also this is lower court. This is higher court. Okay. This is lower court. Adil Imam case is the lower court. But the prosecutor did not challenge the decision. Just for one reason, because Adil Imam is very famous. But we were lucky to have such reasoning. Because this reasoning is exceptional in the Muslim world, I have to say. As I searched it, I searched it for in other court. I haven't found something like that in any other court in the Arab region. For example, Algeria, recently Algeria referred to the case law of the European Court of Human Rights in order to justify restriction on freedom of expression. So they said, according to the European Court, the case law of the European Court of Human Rights, state can restrict speeches in order to protect religious sensibilities. Of course, this is misreading. I mean, this is margin of appreciation. It's a different story, different context. But an Algerian court just referred to the European Court in order to legitimize the use of blasphemy laws. What Ahmed Samih, this judge called Ahmed Samih Rahani, his case, so he started to first. He differentiated between religious doctrine and protecting individuals. So this is the first time a judge, I mean, he went toward Article 20, incitement, not blasphemy. He said shocking views are normal and should be accepted. And also what is new in this reasoning also is that he tried to legitimize freedom of expression from within Islam. So he started to refute the crime of apostasy. And he said Islam is supporting religious freedom, and there is no consensus among Muslim jurists on the punishment on apostasy. This is very important that he started to discuss apostasy because, as I said, you will never touch blasphemy without, you cannot delegitimize the crime of blasphemy in Muslim world without delegitimizing apostasy. Both are very much interconnected. So this is the judge, what he did. He started to refute, to challenge that there is a punishment for apostasy in Islam. Okay? He cited Quranic verses, certain incidents from Islamic history, and so on. And also he started to discuss the different views of Muslim jurists in order to conclude that there is no consensus and there is ijtihad, independent reasoning that can be practiced in order to endorse religious freedom and freedom of expression from within Islamic tradition. Then he actually started to make another interpretation of this article. So he said that this article does not protect religion per se. He said that this article protects society, protect public order, protect individuals, not to protect religious doctrine. And this is also another important principle that he developed in his reasoning. And of course, he cited the UN Human Rights Committee General Comment 34, US General Comment, and he cited the General Comment, and he cited the differentiation made by the committee between blasphemy and incitement, okay? And he cited also Article 20 of the ICCPR. So this is an outstanding reasoning. Then he concluded that Adil Imam did not commit act of blasphemy, and he just released him. So this is a very exceptional precedent. 2012. I mean, in my view, why this case came like that? First of all, the judge himself is young. maybe he's also very much, wanted to, or trained in comparative law, and they trained also in international human rights law. But there is another factor that we need to consider, that in 2012, it was Muslim Brotherhood in power, and Adil Imam is a very famous movie star, sober star. And Adil Imam was known of his criticism of Islamists and political Islam in Egypt. So maybe also the judge somehow influenced by this context, and he doesn't want to give credit to Islamist lawyer who filed the case against Adil Imam. But at the end, he developed this reasoning that can be used, but it is very minor. It is just one case. It is one case, and it is a lower court, okay? But most of the court in Egypt apply this reasoning developed in Islam Al Fegiery case or Muhammad Fahmi Asfour case. So this is very exceptional model in Egypt, and I would say in the whole Arab countries, because blasphemy laws exist even in the most liberal societies like in Tunisia. In Tunisia, there is blasphemy law as well. The constitution, 2014 Tunisian constitution, provides the state the duty to protect sanctities, to protect religion. And according to this article, there is a criminalization of blasphemy, and there are cases, but few cases because it depends on how the attitudes and cultural attitude and political attitude in society. But there are few cases when compare Tunisia with Egypt or Kuwait, or there are few cases in Tunisia. But still the law is there, and the law criminalizes blasphemy in Tunisia. Yes, I would say yes. The prosecutor could. But you know what? Let's assume something. Because Muslim Brotherhood was in power at the time, and there was a deep state in Egypt wanted also somehow to the things that we started to know after the military coup, but it was just having an Islamist party in power. So the state was not 100% ruled by the Islamist president. There are also against the Islamist president. And the Egyptian judiciary also somehow exceptional in that meaning. Doesn't mean that Egyptian judiciary is modern, it is not modern, but it is somehow state supporting the status quo. They are conservative, but they are somehow taking. But all of them are conservative actors, but the judiciary is different somehow in its attitudes, more moderate somehow than Islam. But I would say yes, one is that we need to consider is the profile of the person. Yes, for sure it played a role. Yeah.
What about the contractual obligations of the marriage? The state treated unfairly by a court deciding to dissolve a marriage.
Yes. This is one of the also controversial issue in Muslim family law in Egypt, because especially in interfaith marriage, if there is interfaith marriage between a Muslim woman and non-Muslim, non-Muslim woman and a Muslim man, and there is divorce, usually she will lose custody of her children. But recently, and this is also another evidence how the Egyptian judiciary trying to change this. In 2009, the Court of Cassation in Egypt developed a new precedent, saying that it is not by default that non-Muslim woman will lose the custody of her children. Okay, she will lose if there is evidence that she affects the religious belief of her children. Of course, this is, it's discriminatory because, by default, they consider the children Muslim because the father are Muslim, but it is one step forward actually to keep the children with the mother, because previously it was taken by default, taken from the mother. But now the father need to prove that there is impact on religious belief of the children. Okay, so this is one element, the custody. Second element, so for example, after the dissolution of marriage, she will also, or if the act of apostasy committed, the person will lose also inheritance. There is no inheritance, yeah. And these are well-established doctrine in the Egyptian Court of Cassation. It is not just in Egypt, in many Arab countries, in many Muslim countries, these principles are applied. If there is act of apostasy, I mean, usually there are certain civil consequences imposed on the person. Okay, this is one thing, but there is another thing which is the interfaith marriage, and the interfaith marriage also is surrounded by a lot of complexities, because a Muslim, a non-Muslim woman will not inherit from her Muslim husband. If he died, she will not inherit from him. So he has to do bequest before will, you know, before this, and the will in Islam in certain percentage. Okay, so this is a law in Egypt also.
Freedom of gestation, he could make a will,
but in a very certain percentage, third of the inheritance. Yeah. So this is how because there is a Muslim, because the religion still defines the status of people involved in marriage and the contractual obligation. And yesterday there was actually another case in Egypt for two Christian couple. They are married. Then the man converted to Islam. Since the woman, she is Christian, she filed a case in order to get divorce. Judge refused. Judge refused because usually if there is interfaith marriage, Sharia will be applied. And in Sharia, a non-Muslim woman can marry a Muslim man. So he refused to give her the divorce. Okay, but if this happened on the other side, for example, if a Muslim, if she is Christian, converted to Islam, the marriage will be dissolved automatically, because a Muslim woman cannot marry from non-Muslim man. It's public order rule in Egypt. The marriage is void. If a Muslim woman married to a non-Muslim man, the marriage is void. It's against the public order in Egypt. So that's how, you know, it acts yani, some kind of discrimination. And these issues, by the way, lead to sectarian violence in Egypt and sectarian tension all the time. Okay, especially the question of marriage, interfaith marriage, is very complex in Egypt because we have 15% of society Christian, and there is interfaith marriage, especially between young people. Huh? And usually, I mean, because in our identity card we write our religion in our identity card, so you will deal with in all of your daily life. If you convert from Islam, and you know you need to change that also in your ID, and the court will not change that in your ID. So there are a lot of some Muslims who converted to Christianity, and they go to the Ministry of Interior to change the ID. They refuse to change the ID. So this is some of the difficulties that met by people in their daily life when it comes to conversion and interfaith marriage. Any question? Okay. So this is a case of, I mean, Adil Imam case, which is, as I said, is exceptional precedent in Egypt. So how this law can be reformed? Prospect for law reform. Well, I think there are certain directions that can be taken in order to reform blasphemy law in Muslim world. And I would say we need a transitional phase where criminalization is only limited to, I would say, as a critical, scientific, critical expression. We need just at the transitional phase to differentiate between those. And here I would refer to the European Court of Human Rights. I mean, margin of appreciation invoked when it comes to abusive or provocative speeches Okay, but in the Arab region, it is used against all kinds of speeches. So I think we need, as a transitional phase, perhaps to differentiate between the provocative speeches and the normal critical, constructive criticism of religious doctrine. This is very important for the Muslim world, because I don't believe that today in the Muslim world it will be possible to completely remove blasphemy. We need this transitional phase. But at the same time, the doctrine of proportionality is very important here. Because, and here again referring to European Court of Human Rights, accused of blasphemy because of an abusive manner, like throwing abusive cartoons against the Prophet or something like that in a Muslim country, then punished to death or punished to 5 years in prison or 1 year in prison. No, I mean, there should be some kind of proportionality in the law. This is as a transitional phase, right? Until the situation allow for the complete removal of blasphemy law. But I don't believe that this can happen easily in Muslim countries. You need some kind of transitional phase. And at the same time, the shift from blasphemy, protection of doctrine, to prohibition of incitement, discrimination, or violence. This is very important. And to protect individuals, not religious doctrine. And here I can refer to the case of Adil Imam in Egypt, because the judge himself pointed out to this principle. But reform will never succeed also without drawing on the diversity of Islamic legal tradition to build an Islamic ground for reforms. This is very important as well. Even if court do not systematically discuss Islamic law in its judgment, it will be very much beneficial to ground the right of freedom of expression and religious freedom from within Islamic law. It's very important to convince the public also of removing or amending this law. And here there is a solution, in my view. There is a solution. In Islamic criminal law, discretionary punishment, and if we succeed to shift the discussion of blasphemy from hudud, fixed punishment, to discretionary punishment, in Islamic criminal law, discretionary punishment starts by blaming or warning to imprison or flogging or death penalty. There are different types of punishment. So blaming here, the idea of blaming, it means debate. It means that Muslim scholar or Muslim establishment can refute, can challenge the person who commit blasphemy, can blame publicly. So this is ta'zir. This is discretionary punishment. But it needs political will, of course, to go for that option. But it is in Islamic legal text, discretionary punishment to start by blaming or warning. So it does not necessarily mean that you need to impose penalty, punishment, physical punishment, or imprisonment. You can just debate the person who commit blasphemy within freedom of expression atmosphere. You can just, and this is part of the role that can be played by religious institution and religious establishment. So you don't need to impose punishment on blasphemous speeches. So this is an entry, an approach to deal with the question of blasphemy in Islam, that first to shift the discussion or shift the place of this offense from hudud to ta'zir. This is very important in the first place. Then to apply discretionary punishment and start by blaming the person who commit blasphemy within the atmosphere of freedom of expression. So there is no need for imprisonment of those who commit blasphemy. So I think these are the directions that can be used for reform. Transitional phase, like limiting the scope of the offense under the doctrine of proportionality, just focusing on the abusive and provocative type of speech, not just the academic or peaceful expression of views or constructive scientific discussion of religious doctrine. This should not be charged of blasphemy, okay? But using the doctrine of proportionality is important as well, because you still can impose harsh penalty for abusive speeches. then shift from blasphemy, protection of doctrine, to prohibition of incitement to discrimination or violence, protection of individuals, not protection of religious doctrine. Protection of individuals is much more adequate to protect Muslims in Europe or to protect non-Muslims in the Muslim world, rather than protecting religion per se, because this is self-contradictory. It will always lead to discrimination. If you just apply blasphemy law on religious doctrine, you will always discriminate against citizens in the practical application of the law. But one of the obstacles, just to be honest in this debate, the resistance of political and legal actors. And you need to have constituency for reform, because, I mean, in Egypt today, it is not on the public agenda at all. Reforming the blasphemy law is not even raised. And reforming personal status law is on the agenda, and people discussing reforming personal status law. But reforming blasphemy law is not something, is not a priority in Egypt public debate. So there are few political actors, few political groups who can advocate for reform. And of course, the religious establishment will usually resist this reform. So one way is to promote new interpretation by court. So if judges started to apply gradually the reasoning developed in Adil Imam case in other cases, so maybe gradually the whole interpretation of blasphemy law will change. But this has not happened yet. So we expect more cases in the coming years. I mean, the blasphemy law will continue, and we will continue to see this kind of cases, especially if there is new crisis erupted in Europe, like the Danish cartoons or Charlie Hebdo. You can expect this kind of cases as long as this law exists in the Arab and Muslim countries. And you can expect also violence around the application of these cases, as we have seen in Pakistan recently. But in my view, this is the way how to tackle the blasphemy law gradually in Muslim legal jurisdiction. And I think this is something visible and can be grounded from within the Islamic scholarship itself, because there are answers within Islamic traditions for these issues, but for political reasons, they are just neglected. They are not used in the public debate. Any question on this?
Blasphemy, but generally on Islamic law and reform. Talking about these things, and I just, you know, I kind of reading and names and stuff early, you know, and you mentioned Doha, so the name there as well, and kind of from kind of reforming and reform from within. And I do wonder how much these and then another law comes in the name of religion. So how effective is reform of Islamic legal tradition? In the sense, as long as the state is that, you know, implementing it.
Yeah, on the long term, this is needed, but on the short term, we need also to find answer from within what exists already. I believe in that also, that, you know, it is not here what I'm calling for is not drastic methodological reform of Islamic law. It is the same traditional Islamic laws that we can use in order to mitigate the impact of blasphemy law. So this is something can be acceptable by Muslim scholars, because this is what already traditional Muslim scholars said. When traditional Muslim scholars themselves said that discretionary punishment to start by blaming and end by this penalty. So why Pakistani choose this penalty, not choose the blaming? So you can discuss these issues. But on the long term, of course, I mean, Islamic methodologies and drastic reform of Islamic law is needed in order to mainly reform certain aspects of the law, like equality between men and women. You know, equality between men and women will never happen in Muslim country without tackling some certain methodological issues in Islamic law. And this is the most difficult thing, because today you see, for example, what happened in Tunisia recently. I mean, in Tunisia, if you want to look at this debate, read this recent report published by the Parliamentarian Committee established by Beji Qaid Sibsi. He established this committee in 2018 to start a new phase of Muslim status law reform in Tunisia. And the committee supported equality between men and women in inheritance. And the committee started to challenge the methodology, traditional methodology of Islamic law. And they argued that, well, ijtihad and independent reasoning can take place in certain text in the Quran, in the clear text in the Quran. And nothing prevents Muslim scholar to practice ijtihad on this kind of verses. So this is what have been said in the text of the report. But Tunisia later on failed to pass this legislation because all political actors refused, including liberal, not just Islamists. They refused to pass a legislation that impose equality or bring equality between between men and women in inheritance. So there is limit for reform in the Muslim world when it comes to Muslim family law. I mean, Tunisia, this is one of the most progressive legislation in the whole Muslim world when it comes to equality between men and women. There is prohibition of polygamy, the only country that prohibit polygamy in Tunisia. Of course, Turkey, but Turkey applies civil law. It's not Islamic law. But Tunisia, they apply Muslim family law, but they practice ijtihad in order to reform the law since 1957. So they prohibit polygamy, divorce in court. There is full equality between men and women when it comes to divorce, like what is applied in European civil law. But when it comes to inheritance, they failed to apply because there is resistance from Muslim scholars and religious establishment, and mainly the resistance because it is, again, is the methodology, traditional methodology of Islam to change a ruling that is based on certain text, a text that is clear and certain in the Quran. So this is the idea. If there is a new methodology, then maybe, I mean, this will change. But I would say that the traditional methods are important in order to achieve certain reform, but it has limitations. It has limitations. There are certain issues that it will never be able to deal with. Because even in Tunisia, by the way, inheritance between Muslim and non-Muslim are prohibited. Even Tunisia also is the only country that allow marriage between Muslim women and non-Muslim men. In Morocco, it is prohibited. In Algeria, it is prohibited. In Egypt, it's prohibited. But in Tunisia, Muslim women can marry from non-Muslim women. So there is ijtihad happening. But when it comes to inheritance, they failed. And I believe the failing here because of the methodology. Yeah.
Somebody else wants to ask a question?
As I see this, my reading of it is, if we but it will be fraught with violations, it will be fraught with death, people.
Yes.
We can't assume that it's going to happen overnight. I mean, I as a Christian, have a little different view than others. Making, like you've done, for personal rights. These type of organizations have done great work, and they've been.
And all methods will be used in this battle. Like today, Muslim feminists in Egypt, women rights advocate, secular women rights advocates, they use traditional Sharia in order to apply certain limited reform of the Muslim family law. So at each phase you will need, I mean, it's inconsistent process. You will need different methods, and different methods will engage with each other. It's because it's a historical process. But I'm optimistic of something. Following the Arab Spring, there is surge of rights in the Muslim world, and there are new issues that are discussed. We couldn't imagine, by the way, these issues of blasphemy, apostasy, Baha'i, Shi'i, I mean, tackled by, why they are tackled by Egyptian court? They are tackled by Egyptian court because there are lawyers who challenge this law in court, and there is debate, lively debate going on in societies following the Arab Spring. So I think there is something changing. Right of LGBT is now discussed also in the region. There are associations defending LGBT. There are also groups that challenge criminalization of homosexuality in Egypt, in penal code in the Muslim countries. So it's ongoing process, but it's politically, it's more embedded in the political and socio-political context, I would say. It is not intellectual process. I would say this is not an intellectual. Already, Islam has been reformed intellectually. There are a lot of schools. There are a lot of schools and a lot of literature, but it's about political and socio-political contestation.
That's my issue. Is, so if you take the some law reform since the 1979, there's been so many women's rights, abrogated or Muslims, so on, working on these laws, they make little bit of progress, and then, but then but then it's not just the law; it's the implementation of the law. Law has no place in the state, basically. So unless we have a secular state, it's going to be very, very difficult to have real,
yes, But in order to have this secular state and to have a stable secular state, you need to change some kind of attitude, cultural and religious attitudes. Otherwise, it will not succeed. Look at Turkey.
Yeah.
There is resistance also growing.
There is absolutely. Look at Iran, it's the other side.
Yeah.
You see so many Iranians. Almost recorded here. But
Them are first sanctioned by the political power, like in Morocco, and supported by religious scholars as well. So political power is not enough. So in Morocco or Tunisia, there was some kind of support from the religious school. In Egypt, why the reform is limited? Because first, political power does not have the same political will to go far in reform, and the Azhar does not go far in its reform like Morocco or Tunisia. But all of this reform came from political power, not from society. After the Arab Spring, there are actually political groups that resist this reform and want to reverse this reform. That's why I would say, in order to stabilize this reform, you need also to build the constituency for this kind of religious reform. It is needed. It is not a solution but itself, but you need to have some kind of critical sector in society who believe in that. Otherwise, political power imposed by authoritarian, because most successful liberal personal status law in the Arab world applied by authoritarian government. Once you have democracy, like what happened in Egypt, this reform would have been reversed. Muslim Brotherhood wanted to change the family law in Egypt after taking power. Same in Tunisia, same in Morocco, it came by the king. So this is a problem. You have authoritarian regime who impose reform. But when it comes from society, it is very slow.
The reform is the power, but